Good morning, and welcome to the Burr Broadcast, where we provide you with important legal updates on the latest labor and employment news. My name is Joe Barnello, and I am associate in Burr & Forman's Birmingham office. Today, we're going to briefly discuss a few of the cases the Supreme Court decided this past term affecting labor and employment, and preview what the Supreme Court will hear next term. First, most recently, the court announced its decision in Graf versus DeJoy regarding the definition of undue hardship in the context of religious accommodations. For 46 years, lower courts had allowed businesses to deny religious accommodations that created a more than de minimis cost. In Graf, the court said this interpretation was mistaken. Instead, to justify the denial of a religious accommodation, a business must show the accommodation result in substantial increased cost in relation to the conduct of the company's particular business. The Supreme Court did not provide many examples of this new standard, other than one, employee or customer animosity toward a religious practice or religious accommodation will not suffice, and two, the mere fact that the accommodation would force other employees to work overtime will not constitute an undue hardship. The company has to explore other options, like voluntary shift swapping. The court also explained that the new standard will likely necessitate a case-by-case and even employer-by-employer analysis. Earlier in the term, the court decided Helix Energy Solutions Group versus Hewitt. This case asked whether a highly compensated employee would be considered a bona fide executive under the Fair Labor Standards Act, despite being paid on a day rate. In short, the answer is no. Because the company did not guarantee that Hewitt would be paid the threshold amount on a weekly basis, he was not exempt from overtime pay. In other words, the day rate did not satisfy the salary basis requirement of the bona fide executive exemption. Finally, in Mallory versus Norfolk Southern Railway, the court opened the door to the possibility that companies would be subject to defending a lawsuit in any state they are registered to do business in. While alarming on the surface, at this time, the court merely said that each state has the option to include this in their registration statute. Many do not. And companies will still have a viable argument to avoid personal jurisdiction going forward through the Dormant Commerce Clause. Quickly, two cases the court is scheduled to hear next term are Ashton Hotels versus Laufer, which will decide whether so-called tester plaintiffs have standing to challenge failure to provide disability accessibility information on business-related websites under the Americans with Disabilities Act. And the second case is Muldrow versus City of St. Louis, in which the court will analyze the scope of adverse employment actions for Title VII discrimination cases. If you have any questions regarding these topics, please do not hesitate to reach out to Burr & Forman's Labor and Employment Group. Our team is always prepared to help you navigate these issues. Visit us today at www.burr.com.